Hey everybody, my name is Ryan Malkin, and I'm an attorney in the alcohol beverage industry. I have a law practice based in Miami, Florida, and Malkin Law. And today I wanted to talk to you a little bit about bottling agreements. As with all legal discussions, I just wanted to let everybody know that this does not establish an attorney-client relationship and is not supposed to be deemed as specific legal advice, but rather just for informational purposes. A lot of Park Street clients do enter into bottling agreements, and Park Street helps with that whole flow, which is great. But when you're going to enter into the bottling agreement, there's a few things that you should keep in mind. First, of course, you want to make sure that you guys are on the same page, and that's what the agreement would pretty much outline. One thing to consider is the bottling supplies. Who's going to be responsible for that? Things like the labels, the caps, the cartons, the actual bottles. Are you getting a custom bottle made, in which case you're probably going to be sending it yourself? If it's a stock bottle, are you paying for it, or is the bottler paying for it because maybe they have a line to them and a good deal, and then you're going to reimburse them? If you're going to be sending the bottling supplies to the DSP, you want to make sure that you guys are on the same page in terms of when they can arrive prior to the production run. Maybe it's a couple days if they don't have a lot of space at the DSP. Maybe it's a week or a month. So you want to make sure you guys know how long the product sit in their warehouse in terms of the supplies, and then once the production run is done, how long can the product actually sit in their warehouse before it has to be picked up by Park Street or distributor or whoever it might be. The other thing that's very important, especially if you're creating a new unique product, maybe it's a unique blend of some sort or has a specific formula that is proprietary to you, you want to make sure that you own that formula. So even if the bottler is producing it for you or creating it for you on your behalf, you want to make sure that you own that at the end of the day, so that if something happens and you go to another bottler, you own that recipe, you can take it with you, and that's your intellectual property, and obviously that's part of the value of your company. So that's particularly important. And that can all be addressed in the contract. You also want to consider samples of the product. So in terms of production runs, you should probably think about having a sample you both agree to. After that, that sample A is what you say you want produced. And then you can also suggest that maybe you have samples run before each production run down the road to make sure they all are the same to you as sample A, whether that's through your own nosing and tasting or through lab analysis is up to you. But you want to make sure that you're getting sort of what you thought and what you paid for. I've had situations where they thought they were getting A, and then the actual bottling came, they opened the bottle, and it wasn't the same as A, and it was actually something a little bit different, sample B, and none of the parties were happy. You also want to consider the fees. So are you paying again for all of the bottling supplies? Now are you paying for the production run, and does that include all the administrative fees, or are there other administrative fees like formulas and labeling that you're going to pay for on top of that? You just want to make sure that you know what you're paying for and know what you're getting. Similar to that on the FET side, is your fee to the bottler inclusive of the FET or not? And then of course you want to think about the Craft Beverage Modernization Act. Are you getting that benefit to you, or is the bottler keeping it for himself or herself for her own production? So we want to make sure that you outline that and ideally get it for yourself. The next thing to think about are what we refer to as the reps and warranties, and that's that we want to make sure that the bottler is going to take responsibility for things like complying with the law, obviously, complying with FDA and TTB guidelines, also that they're going to protect you if something happens and they produce a product that's not compliant. Because you're not producing it, if someone sues you as the brand owner, you want to look to the bottler and say, hey, you should indemnify me because you're the one who actually made it. So you just want to make sure all those things are clear in the agreement. Then the next thing you want to be sure of is the flow. So that means once the product is produced, then what? Is it that the bottler is going to be selling it to wholesalers? In this case, Park Street will likely be picking it up, moving it to its warehouse, and then selling it either through their self-distribution channels or to another wholesaler. That's the likely path for most Park Street clients. And at the end of the day, you just want to make sure that you guys are on the same page and of course include things like the trade name on the back if you want it to be produced by Ryan's Distillery versus XYZ Distillery. You want to include that in the agreement so everybody knows what they're getting. Should you have any questions, feel free to reach out. My email is ryan@malkin.law, MALKIN.LAW. Thanks and have a great day.